Thank you for your testimony. Mr. Walker, welcome. Introduce yourself and go ahead.
Thank you, Mr. Chairman. My name is Jack Walker. I'm the president of the Texas Trial Lawyers Association. I'm here today with my colleagues to testify in opposition to Senate Bill 30. Senate Bill 30 is not just one bill. There are 4 sections of this bill that we will testify to today. In my time before you, I'm going to go through each section, identify the subject, and give you a brief explanation of what it contains. My colleagues will then go through in more detail, identify the issues in each section, the dangers they present, and why they won't work. So let's start with section 1. We'll call this the medical expense section. This section redefines how medical expenses are proven and valued at trial. In many cases, this is going to limit damages to 150% of a threshold. These are not market rates, they're administrative rates. This creates a cap on damages disconnected from actual medical costs. In some surgical cases, this cap would reimburse less than 50% of what the surgery costs. So if this cap are applied and you're at trial, the defendant is found negligence, the plaintiff is found to get damages. If the cap is applied and it's 50% of the cost, the plaintiff, having won, is still going to be responsible for a large portion of the bill, even after being the victor. Now, Section 2 purports to redefine non-economic damages. This is perhaps one of the most damaging parts of the bill. What this does is completely guts non-economic damages recovery and will devastate the most vulnerable, catastrophically injured victims. Texas currently recognizes at least 6 elements of non-economic damages: pain and suffering, mental anguish, disfigurement, physical impairment, loss of consortium, loss of enjoyment of life, and these are important. These damage elements were developed at common law over time to cover the full range of human suffering that can result from these serious injuries. Senate bill guts these definitions and reduces it down to 2, physical pain and mental anguish. And then what it does is it then raises the bar. It redefines mental anguish and physical pain so narrowly that they become almost impossible to prove. This redefinition is not designed to clarify mental anguish or clarify physical pain. It's actually meant to disqualify it. The result is simple. SB 30 reduces human suffering to a checklist. And if you don't check the right box, your pain and your mental anguish is worth nothing. I'll give you an example. A victim who's been permanently burned in an industrial accident will no longer be able to recover for a lifetime of disfigurement because it's been stripped out. A victim who at the age of 25 has her leg amputated as a result of a defective product will not be able to recover for that lifetime of physical impairment. Now we'll go to section 3. I'm going to call this the disclosure section. This is perhaps the most bizarre section of the bill. This forces disclosure of irrelevant information. It requires disclosures of letters of protection, referral relationships, financial arrangements, all of which are not relevant to the actual issues in the case. But the bizarre thing it does, then after it's disclosed, it mandates that all of this is admitted into evidence with no judicial oversight. It is completely one-sided. There's no additional obligation on the defendant to produce anything. It only applies to the plaintiff. An example of this is the referral relationships between doctors and lawyers, okay? Now, this has been a subject of the first part of the bill, but I'll give you this. I was raised and still live in a small town in Tyler. I send people to doctors all the time. My father's an orthopedic surgeon. Somebody comes to me and says, I've got a foot and ankle problem. I say, go see this person. They're the best. Go see this person, the best. Under this bill, if I do that, then I have to go back for 2 years, figure out if I've ever sent somebody to a bill, and then sits into the doctor, and then I gotta disclose the amount of money that my office has paid to pay the bills of my clients. It's not about transparency. It's about tilting the courtroom against injured Texans. Now, finally, I'm going to take issue with Mr. Parsley, as you thought I might, about the non-economic damage caps. This is a cap bill. Do not be fooled. The Texas Constitution guarantees a right to trial by jury, not trial by formula. This remitter scheme in this bill allows a judge to override a jury's verdict based upon artificial caps and not the facts of the case. The bill doesn't just limit damages, it rewrites the jury verdict after the fact. That's not reform. That's an unconstitutional intrusion on the jury's core function. The jury is the sole fact finder. A judge has no ability to overturn it. We would ask that this bill not be passed. Thank you. I'll answer any questions you have about any section of the bill.
Thank you for your testimony.